Good morning, and thanks for joining us for another edition of the Elville webinar series. Today is Friday, February 7th, 1 week before Valentine's Day. Our topic for today is what families need to know about planning for a loved one with special needs. And your presenter is our very own managing principal and lead attorney, Stephen Elville. And I'm Jeff Stauffer, and I'll be your moderator for today. And a few housekeeping items. We have lots of people on today, so welcome, and we encourage your general questions throughout. More specific questions, you can ask Steve or have a consultation with him after the presentation at a time soon to be determined. Your questions always add a lot of value, so thanks in advance. And yesterday by email, you received the presentation slides that we're going to be referencing today. So please, if you didn't receive those for some reason, they're available in the section marked handouts in the screen to download at this time. And we have some professionals on today's webinar. Thanks for being here as well. And most everyone can receive 1.5 continuing education hours for attending. So send me your ID number or an accreditation, and I'll be sure to get your hours submitted and certificates sent out as well. And everyone will also receive a post-webinar feedback email right after the presentation. This is really important to us to offer your feedback to us, and we look forward to getting that and taking just a couple minutes of your time to do that for us. And a question for you. Have you achieved your planning goals, or have those goals shifted since you last looked at your planning? And here at the firm, we always want to be a resource for your family's planning needs, whatever it may be: special needs planning, an administration matter, estate planning in general, business planning, whatever. We are here to discuss and advise and counsel you throughout the entire process. So I'd like to offer Steve and the firm a brief introduction, and we're going to jump right in. Lots to cover, and as always, just not enough time, right? So let's take a look here. Elville & Associates, founded in 2010 by Stephen Elville. I've been fortunate to be here for 11 and a half years of that. It's been a great run and looking forward to many more. We have a lot of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, along with tax planning and asset protection techniques. And we have 9 attorneys, 12 staff members, and 3 locations. And our mission, it's always been the same and always will be, to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And you'll hear a lot about education today and working with Elville & Associates. And we offer that in several different ways. We offer it through our planning processes with our clients. And we have different programs here at Elville & Associates to suit all families and individuals, whether you have more limited means or much larger means. We also offer educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, one of only 2 firms here at Elville & Associates to have a client care program accredited by the Client Care Academy in Boston in the state of Maryland. We have our first client care program quarterly event coming up on March 15th, and looking forward to seeing our members and their guests there. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. Lots to be said about Steve, but we'll keep it to a couple paragraphs. His work as an attorney for the past many, many years has been centered in elder law, special needs planning, and estate planning. He's a member of many different national membership and professional organizations, including peer groups, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, the National Network of Estate Planning Attorneys, and many others. He works to offer peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. And Steve is a very seasoned speaker and presenter, each year offering many webinars, workshops for businesses and their employees, conferences, and continuing education events. And Steve was named to the Maryland Super Lawyers list for a 10th time and a 9th consecutive year in 2025. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very fortunate to be a part of. I did just send out an update about the Elville Center and what we've been doing for the past several months yesterday. You may have received that. If you'd like to learn more about what we do each day, please reach out to me, and I'll be very happy and pleased to share our story with you. But for now, we have an important topic to discuss, all about special needs planning, and there's nobody better to do that then Mr. Stephen Elville. So Steve, I'm gonna make you the presenter here. Turn it over to you.
Well, thank you, Jeff. Good morning. And I will say I'm not so sure about that. I'm very humbled by your words, but it's my privilege to be here giving the information. And I want to thank everybody on this Friday morning for being here and spending your valuable time with us. I also want to thank Jeff for being here this morning, even though he's really under the weather and is very much not feeling well this morning, probably with flu symptoms. So thank you, Jeff, for continuing with the webinar this morning, even though you don't feel well. And I just want to say to everyone, a happy weekend ahead. I understand we have an ice storm coming. Jeff, you're usually right on top of the weather. What do you know about it?
Well, as the amateur meteorologist that I am, Steve, I will say that there will be some light snow transitioning to ice tomorrow, followed by a pretty big snowstorm on Tuesday. How's that sound?
All right. All right. Thank you, Jeff. Well, everybody be careful out there. And again, for everything that Jeff just said, I could not do it without him and his work with me over these past many years and all of the associates and staff here at Elville and Associates. So thank you again, everyone, whether you are a client or prospective client or someone here just to get information or a financial advisor or a CPA or a life insurance specialist or an aging life care manager, wherever or whoever you may be this morning, wherever you may be, welcome. And it's my privilege. So I want to just get right into the information this morning because we're going to go through a session here. You will have opportunities to ask questions. You will take away some substantive things. And the most important thing here today is really to ask ourselves, why are you here? Why are you here? Do you have an existing special needs plan that you want to review or revisit? Do you have specific questions and you're trying to get started with special needs planning or your own estate planning? The thing to remember is that there is nothing to fear, and I want you to give yourself permission to be able to absorb the information and move forward with it. And the most important thing is for you to walk away today with some substantive things, including the slideshow, which in and of itself is a lot of information for you that you can use as a reference. So remember, special needs planning is many things, and we're going to talk about that. And we know that disabilities or special needs, they don't discriminate. They cross all of us in society. Wherever we are, no matter how large our estate or modest our estate or financial worth is, it does not discriminate with people. So we're here to talk about and learn about special needs planning. So thank you for being here, and Jeff, thank you again. This is not meant to be an attorney-client relationship. There is no legal advice here that's being given, because this is just high-level educational material. But if you would like to meet with us or our associates here, we will engage in an attorney-client relationship. Even if you just consult with us, it is a confidential meeting. The attorney-client confidentiality does attach to that relationship. So there is nothing to fear as you think about finding out more information or about how to do planning. So all planning is goal-driven, G-O-A-L, goal. And what I want to do here is just ask you, why are you thinking about planning or revisiting your planning? But planning for a loved one with special needs or disabilities is usually, not always, but it's usually about enhancing that person's quality of life to a maximum possibility. We want to protect that person. We want to not limit that person. We want to provide for security for that person and many, many things. And this is where I just want to take 1 minute, and I've got my timer here on my phone, and I want to just give you a minute to just get settled, get centered in your own mind. What are you doing here today? Where are you right now with your thinking about your planning, and what is important to you? So let's take 60 seconds on this, and I'm going to hit my timer now. If you have a tablet, a piece of paper, a computer, an iPad, whatever it may be. Write down some thoughts. Don't try to second guess it. Write down whatever comes to mind. I think you will find this exercise is worthwhile. Just write freehand, free thinking thoughts. A little bit less than 30 seconds left. There are no wrong answers. Let it come to your consciousness and come out on paper or the tablet or your phone. Five more seconds. Okay, thank you for sitting through that exercise with me, and hopefully you've jotted down some things or even at least made a mental checklist. Here are some of the benefits of planning, and it can be financial security related. It could be to understand public benefits and leverage those means-tested public benefits. Some of your loved ones are not on public benefits, and you might need to still do special needs planning for some esoteric reason or hybrid reason. A financial advisory team or a CPA or a life insurance specialist, we may need to assemble a proper planning team. Maybe your loved one is in need of appropriate housing, or you as an individual or a couple are very concerned about how housing will be provided. Advocacy, caregiving needs, coordinating with the family. Will the family members largely be involved versus outside parties? How do we protect our loved ones with disabilities who are many times vulnerable from creditors, from predators, from fraud and abuse? And then for some of you, it is going to be an added bonus that you can plan very well on the front end for special needs planning and still preserve assets for others if, God forbid, our loved one with disabilities passes away and there is still a certain amount of funds available. So all of these reasons plus your own, which I want you to have really taken to heart, because most of you do not have time to think about this. And today, in this space that we have together, we're going to take the time to think about it. So I'm going to be redundant at times. Jeff and I, as we've presented over the years, have found that this is helpful. I'm going to repeat myself. Sometimes it will sound like I didn't mean to do it, but I'm really meaning to do it intentionally, of course, to emphasize things. Having the right team of advisors is really important. Not everybody is going to do this or need this, but most people would be well served by having a group of advisors. If you don't have that group, we will help you determine how to do that. Flexibility, building in flexibility. If I had met you in this time and space we have together, if I had met you 20 years ago, I would not be able to sit here today and say, hey, we can build in a lot of flexibility into the planning to deal with changing circumstances in the future. I would not have been able to say that. But thank goodness the law has changed. The laws are more flexible. There's more maneuverability, I guess, in the future for the planning after we are no longer here or if we were incapacitated. Advocates. One of the biggest issues in special needs planning today is who will be the advocate for our loved one. Trust protectors. Learning about the special fiduciary that is called a trust protector can be one of the ways to add flexibility to your planning. A trust protector is a special fiduciary who has limited powers to deal with trustees, changing trustees or removing trustees and replacing them, or being able to amend a trust if it needs to be amended in a certain administrative way. All of these things are things you need to be learning about. So let's talk about how to create an effective plan. Well, some of this is what we've covered so far. You need to take the time to think. You need to have a vision, right? Where will your loved one live? And many of you know this. You already know this, and you've done a great job with this. And others of you, it's not that you didn't do a great job of planning, but you are still in the process of figuring this out, okay? Will there be a conservator or a guardian, meaning guardian of the person or guardian of the property. So will your loved one with disabilities need a guardian? What other kinds of things that are going to be involved that we haven't thought about, that we need to sit with our advisory team and think about? What kind of lifestyle are we trying to provide for our loved one? And that's going to largely be driven by circumstances or finances. But remember, there are tools to be able to fund assets into a plan, like life insurance. So we want to be mindful of that. What are the future challenges? Now, many of you right now could be, depending on, and it doesn't really matter what side of the political spectrum you may be influenced by one way or the other or believe in, we are all facing the issue of change with the current new government in place and talk of cuts in Maryland for certain programs. These are going to be very concerning. What are the future challenges? How will the Medicaid program be delivered? So we want to, in a nutshell, plan for flexibility for changing future circumstances that could happen, or maybe they will not happen. And for those of you who are concerned about this, I'm happy to speak with you privately to be able to maybe offer some way to think about this. And I know many of you are worried about it, and we can discuss this. So we want to build layers of flexibility, layers of fiduciaries, meaning who are the trustees, who are the guardians, who are the successor trustees, who are the trust protectors, and so forth. And we want to understand our process. So if I could leave you with one major thing to take away from today at the end of this hour would be good planning is goal-driven and it is process-driven. And again, as we started at the beginning, you should have a purpose. And if you don't really understand your purpose, I can help you, we can help you have an epiphany through counseling about what the purpose of your planning can and should be. Now, one of the big things that you can do, and I've seen more of this recently than I've ever seen, is create a memorandum of intent. You can create a memorandum that goes along with your special needs trust or your will or your revocable trust planning. You could also create a binder of information that goes along with your memorandum of intent. What are the preferences and needs and wishes of your loved one? Who are the key people? The family members, the trustees, the caregivers. What are the benefits they receive? Where is their social security statement every year? All of these things can be put into a binder, or you could just use a memorandum. So arguably, when you do this, you are personalizing your special needs planning for your loved one, and you can do it in a flexible way where it can be updated over the years. So just know that if you would like to see a sample of a memorandum of intent, we are happy to send you one or to assist you with the creation of a binder and other information that you may want to attach to a trust. Does everyone do this? Absolutely not. So I would say I probably wouldn't be far off to say that about 95% of all trusts have no memorandum or no binder attached. But when you do this, you are separating your quality of planning you're creating a very high quality plan versus someone who would not personalize it. It is a lot of work, and yet it is rewarding. So when you look at the financial aspects of this, and many of you have financial advisor relationships, or you act as your own financial advisor, or you deal with large brokerage houses like Fidelity, Vanguard, Schwab, or others where you direct your own financial planning. But we want to look at the future of the planning, and we want to use the financial advisory resources, the ability of a financial advisor to project. Some people would call it a Monte Carlo simulation, or have a CPA run numbers about how much money will be needed in the future. And of course, many of you will be relying on public benefits or the public system, but we need to have a healthy awareness that the supplemental needs trust, or maybe we call it a special needs trust for today's purposes, that special needs trust is creating a world for your loved one outside of the world of public benefits. That has always been here, it seems. It's always been here. It probably always will be here, but we can't take anything for granted today. So when you create that trust, we want to make sure we have a funding mechanism for that trust not just taking a chance on how much is going to be left at our debts, because none of us really know how much money we are going to have when we pass away, if we were honest. So we have to really think in terms of how can we make sure that we understand the future needs and the funding of the trust. Now, this is an old-fashioned spreadsheet. I'm sure you can use other resources you have or create your own spreadsheet. Again, use your financial advisor's resources. And if you don't have any financial advisor, we will be glad to work with you to find an appropriate financial advisor that does have these tools. Planning for incapacity for your loved one. Let's talk about this now. Some of your loved ones with disabilities are going to be what I would call higher functioning, and they have the mental capacity to execute their own advanced directives, financial powers of attorney, and so forth. Some of them will not. Some of them will need a guardianship of their person and property, and many of you are already the guardians of your loved ones. And so what we want to do is really take a look at this as part of good planning. If you haven't already addressed it, or maybe it's something you have not been, you've been reluctant to address. And we also want to understand supported decision making, which is a mechanism now where a person with disabilities has a more official recognition of the right to have accommodations and also to have their rights of self-determination expanded, so to speak. So these are things that you need to educate yourself on. We have done a webinar that Jeff will be very happy to send you a link to, which is a webinar about supported decision making. And many of you have now become much more aware of what this is. So we want to distinguish between someone who can sign documents that has mental capacity and name an agent and avoid guardianship, someone who needs guardianship, and someone who might be able to avoid guardianship with supported decision making and really understand that continuum. So let's talk about public benefits. And just a rhetorical question for you. Do you think that most trustees really understand this? And of course, the answer is no. So I would like to offer a book recommendation. And this is not fun reading, but it's not horrible reading. And this is, there are many books about special needs planning and so forth, but I would like to recognize someone named Kevin Urbash, U-R-B-A-T-S-C-H. Kevin Urbash, he is either the current or past president of the National Academy of Special Needs Planners, and he wrote a book, How to Administer Special Needs Trust. But the actual name of the book is How to Administer the California Special Needs Trust. He happens to just be located in San Francisco, but even though it does mention Medi-Cal, which is the California version of Medicaid, quite a bit, it is a very, very good book that is easier to read, and I highly recommend that you read a book like this or have a potential trustee commit to learning about public benefits. All right, as we get ready to get into this slide, Jeff, I think we're doing very well on time. So let's look at how I would recommend you think about public benefits. And many of you are already very, very astute about this. But if you're not, I want you to open your mind now to these three categories. On the left, we have SSI, which is the quintessential definition of disability, supplemental security income. And many of you have children that have turned 18 and are on SSI. And as a result, they receive Medicaid, medical assistance in Maryland. Now, if that child is on a rather familiar track of going from SSI to SSDI someday, this could be a person who is a disabled adult child. This could be a person who they were disabled prior to age 22, and when their parent retired from their job and started taking Social Security, or the parent died, this person is now going to switch over to SSDI because they do not have a work record of their own in this particular case. They are getting SSDI based on their parents' work record. Now, as you can imagine, there are all kinds of situations that occur, but I'm giving you just the bare minimum examples of how to understand these slides. So the person who was on SSI will eventually go to SSDI if they are a disabled adult child, if they were disabled prior to age 22, and they will start receiving SSDI, Social Security Disability, and this will be on their parents' work record, and that's going to mean they get 50% of the amount that is equivalent to what their parent gets, and 75% after the parent dies. Now notice that the person who moves into the SSDI category, it could very well be a person who's still going to be receiving Medicaid. So a typical person who is an adult disabled adult child is on Social Security Disability. By virtue of that, they get Medicare, and then they get Medicaid as well. And this person is still going to be the kind of person that would need a special needs trust in a basic way. So we have SSI, SSDI. Is SSDI means tested? The answer is no. A person could have $1 million in their bank account and still get SSDI. The person with SSDI could have a work record of their own, and many of your children or loved ones with disabilities do have work records of their own. And so it's just a question of, are they receiving SSDI on their work record, or are they a disabled adult child and receiving SSDI on their parents' work record? Now, as we go to the right category, we're not going to spend a lot of time on veterans benefits, which is another subject in and of itself. We will spend just a moment, though, on Section 8 or HUD housing. Some of your children or loved ones may or are receiving benefits through having HUD housing. And prior to 2024, it was a very difficult situation. If a trustee of a supplemental needs trust or special needs trust were to make a distribution for the benefit of someone who lived in HUD housing, it would affect the HUD housing in a very negative way, where the distribution would be considered to be income to them that would increase their rent. I'm happy to say that the HUD rules have been revised in 2024, so this is not such an onerous situation. So we won't spend a lot of time on HUD, but I wanted you to start getting your mind around these three categories. We're not going to spend a lot of time on the supplemental security income tests. These are references for you. The definitions of disability, the countable resource test is still the same. Notice that a person who is on SSI still could own a home. I'm not saying it would be a good idea for the person to own a home. Maybe their trust should own the home, but they still could own a home and it would not affect their SSI. The value of an automobile, or the automobile of any value, I should say, that person could have a vehicle. So just because a person is on SSI does not mean they could not have a vehicle or a house, but in many cases, most cases, they would not own the house in their own name. There are exceptions. Now, the Social Security or SSI rate for 2025 is $967 a month, and in some jurisdictions, there is an additional small amount due to housing costs. I want you to start understanding, and this is one of the reasons I would want you to read those books, or a book about understanding means-tested benefits, about SSI and the concept of unearned and earned income. We will just spend enough time on this slide to say a person who is earning income in any form, earned or unearned, could earn too much income and their SSI could be eliminated. So we just want to understand this at some level about how SSI is reduced depending on how much your loved one is working. And we don't want it to be reduced to zero because it could affect or it would destroy their Medicaid. In-kind maintenance and support. Many of you have a situation where your loved one is living at home. If they're not paying rent, then what's happening is you're probably getting a reduction of 1/3, which is the maximum amount that they can take away, because you are providing in-kind maintenance and support to your loved one. But if they are paying rent, which is easy to do if you would like to find out more about that, then Social Security will say, oh, well, we're not going to take away that 1/3 anymore. So there's no need to lose 1/3 of the SSI amount if you are experiencing that. We can talk about that.
Hey, Steve,
So
can we pause for a
go right
question?
ahead, Jeff. Let's take a break and I'll take a drink.
Thanks. Can you repeat about the SSDI portion not affected by the amount of assets?
Yes, thank you. So a person, let's say that I was, just to try to understand this, let's say that I was working and God forbid I became disabled, but I have a work record and I've been working for my whole life. So now I get Social Security disability, let's say. Well, when you think about it, Social Security disability is not means tested. I don't have to have a limit of $2,000 in my name. I could have $1 million in my name, and I could still receive SSDI because it is not means tested. SSI is means tested, and many public programs like the waiver programs and other things are means tested, as you may know, because I would not, or the person with disabilities would not be able to qualify for those if they had more than $2,000 of assets in their name, whereas SSDI is not subject to that asset limit. It just so happens, and this is very confusing, that people that are disabled adult children and they are on SSI will eventually graduate to an SSDI benefit, many times based on the parent's work record and not their own if they don't have a work record. And that person will receive SSDI, Medicare, and Medicaid or medical assistance if they are in a program that is means tested.
Okay, thank you. And one more. Which parent's Social Security record is used? One parent currently retired, others still working, individual is age 24.
Thank you. I think it's going to be the first person who retired, right? And then eventually when you both retire, there's probably an adjustment. But that first person to take Social Security, in my experience, has been the trigger for this to happen.
Okay, thank you.
Thank you, Jeff. All right, we're going to keep going. The definitions of Social Security disability, you see here after 24 months to 25 months, the person gets Medicare. Many of you have experienced this. Here is the slide about the disabled adult child. So those of you who have questions about that, please look at this slide 22. Medicaid and Medicare, we're not going to spend a lot of time on, but just remember these are the foundational public benefits. One is means tested, one of them is not, and this is for your reference. Again, we talked about Section 8. This is a big concern about housing, but remember now you can have less concern about the HUD rules being so onerous like they used to be, and you do not have to worry now like we did before that distributions from a special needs trust would really negatively affect someone who is on HUD benefits. All right, so I'm just going to slip on by these HUD rules, but you see here in slide 27, there are new rules. So this is very, very good. And again, we know that's for some of you, the housing benefit for your loved one and how the housing is going to work is a huge thing. So when you are doing special needs planning as part of the process, there needs to be a discussion and a clear-eyed view about how the housing is going to work for your loved one. All right, now many of you are attending today. We're doing good on time. Many of you have attended specifically to learn about special needs trusts, so let's get right into that. I want you to take this slide 31 to heart, this graph, and I want you to read from left to right. So at the top of the page, we want to focus mainly today on what we call the third-party trust. Now, the technical term for this trust is the third-party supplemental needs trust. The third-party supplemental needs trust. That's a mouthful. But if you read left to right, it says anybody can create this for the benefit of a disabled person. So a person who creates this is a third party, usually a parent or a relative, and the beneficiary cannot establish this. This is a third party trust. Why is it called that? Because when you pass away, you are leaving money, whether it's non-retirement assets or whether it's life insurance assets or retirement type assets like IRAs, you're leaving those assets into a third party trust. And the government says, well, if you leave that money as a third party for the benefit of another, and that trust is a discretionary trust, it is a trust, let's say it was a Maryland trust under the Maryland Discretionary Trust Act. Well, that is a supplemental needs trust, and that is exempt. No matter how much money is in that trust for the benefit of that person's benefits are not going to be affected, and that money can be used to supplement that person's life. That is the bread and butter of special needs planning, and that's what most of you either have already or you need to implement that for your loved one. Now notice in the right-hand column at the top, it says that upon the death of the loved one with disabilities, God forbid, whenever that happens, the assets can go wherever you want them to go. So there is no payback to the state or any other state. That's where we want to be. Now, look in the middle and look at the last column down. We see references to the United States Code. And you don't have to remember this, but those of you who want to know where this is, it's 42 United States Code, 42 USC, 1396P, 1396P, D4A, D4C. These are code provisions in the United States Code. From 1993, these provisions say that if a child with disabilities or a loved one with disabilities receives money they should not receive, this money knocked them off benefits. This money ruined their benefits. You as a parent or a loved one do not have to worry. Those assets can be moved out of that person's name. But what is the trade-off? Well, the trade-off, if you look all the way to the right, is there is a payback to the state. Now, sometimes we can't avoid this kind of trust. Someone had a birth injury and they got a settlement. Someone has another type of settlement from a car accident. Someone has money, they were an older person, they have money they shouldn't have in their name because they can't get public benefits. Well, these monies need to be moved out of that person's name. Sometimes it is a parent who is a military veteran, and military veterans can leave their pensions in a special needs trust. This has been the law now for the last 10 or 15 years, and only a first party trust of a D4A type can be used, basically. So we have third party trust, that's your bread and butter, part of your will or your revocable trust plan. There's the supplemental needs trust, third party, no payback to the state, or we have the D4A, first party trust, or D4C, which is a pooled trust, first party trust. Both of those are going to be first party trust. The person has received money in their own name, and we've got to get rid of that and not destroy their public benefits. So that's what we are talking about here. Now, as I just mentioned, the third party trust is the best tool in estate planning. It is not very difficult to understand. So please give yourself permission to just say, yes, I can do this. I can understand this. For those of you who have third-party trusts for many years or several years, it may be time to update them. Maybe they were drafted in a way that's fine. Maybe they are plain vanilla, so to speak, and they need to be improvised. They need to be updated, and they need to have flexibility. Let's stop on this slide for just a minute. I know you're not going to make these mistakes, and I'm just going to say, in all seriousness, do not make these mistakes. So if we leave an outright inheritance to a person with disabilities, they could lose their SSI, they could lose their Medicaid, they could lose their public benefits or their waiver. We know that. So please do not do that, and I know you won't. But here's a problem. What if we are taking the advice of someone out there in the world, an attorney, and that attorney doesn't really know what they're talking about special needs? And we see this occasionally, probably more than occasionally, but not every single day, certainly. But What if you left your money to a trust and you thought in good faith that this was a supplemental needs trust, a special needs trust, but it wasn't? It was really a trust that was not what it should have been. That will cause a loss of benefits as well. Some of you might think, or maybe have already planned, to leave money to other relatives, disinherit the person with disabilities. That's not a good idea for the following reasons. What if you left assets to a sibling of yours, or to a brother or sister of the person with disabilities, meaning another child of yours, and you said, please take care of this child with disabilities. We know you will. Here's the money. Well, the problem with that is the person you left that to could lose that money to creditors of theirs, meaning someone is suing them, or they're getting a divorce, as you see down here in those bullet points. Or maybe they've decided years later that they don't want to take care of their loved one with disabilities. Or what if they died? What if you left the money to this child who's not disabled, and that child died and left it? Maybe they didn't have a will and it went in a different direction. We don't want to do that. And here's the last one I would throw out. What if the child that you left the money to, you didn't know this, but they had an IRS lien, or they have issues with the IRS? Wow, that could be a problem where the IRS might get that money. So please don't make these mistakes. These are kind of like Band-Aid things that you would try to do. It's not good special needs planning, and we don't want to do these things. So the third-party special needs trust, and for purposes of our discussion today, we may call this a supplemental needs trust. The third party creates the trust. It does not hold any of the beneficiary's own money, whereas the first party trust would hold the beneficiary's money. There's no payback. We're just kind of going through this again so you can get some grounding in this. That trust could be irrevocable or revocable during the life of the grantor. It depends on what the situation is. Now let's focus, as we only have about 15 or 17 minutes left, let's focus on this slide 36, choosing a trustee. We also do many workshops on trustee selection. Probably nothing could be more important than choosing a trustee. Elville & Associates acts as trustee through our Waypoint Fiduciary Services, but there are many trustee choices. You may have trustee choices through your financial advisor or through one of the big brokerage firms. You may have trustee choices with family members. And what you're going to want to do here is really go through a process of thinking about this. For some of you, it's completely already decided. You know who your trustees are going to be. But we also need to evaluate what is the difference between a family member and a professional trustee, like a corporate trustee, versus an attorney. Remember, not all corporate trustees are going to serve as trustees for a special needs trust. That's something you need to remember. And not all corporate trustees will actually follow through, even though we don't dislike corporate trustees here at Elville & Associates. We work with a lot of corporate trustees. Just remember, when you are creating your planning, you have to be sure that your trustee, as in this last bullet point, your trustee is available, they have the ability and the willingness to serve. Now, for those of you who may start worrying about this, remember, by building in flexibility, you can have mechanisms where no matter what happens with trustees, there will be no such thing as a trust not having a trustee. In other words, there will be a trustee and you do not have to worry about that, and you can make a trust flexible in that regard. So thinking about flexibility, some of the modern options in special needs trusts are to include provisions about advocates or trust advisory committees. This is not going to be needed for all cases, but it's nice to have it in there. In some cases where there is mental health issues or more volatile issues, a trust advisory committee can be a very nice tool for the trustee. Talking about flexibility here, we're talking about the trust protector. Remember, the trust protector can be given many different powers. Maryland has recognized trust protectors since 2014, but a trust protector can remove and replace trustees, review accountings, change the trust administratively, or be the impetus to change the trust. This is something that takes a little bit of getting used to. So if you have never heard of this, I want to give you the permission to feel somewhat stunned by this, that you could appoint a special fiduciary that has these kinds of power. And this is a good thing that I would encourage you to embrace, but a trust protector is not required, although we think it's a good idea for flexibility in most cases. There are many, many different ways a trust could be structured, but in special needs planning, this is how I like to look at it. Our trustees have been carefully selected. We have flexibility with a trust protector. We have provisions for able accounts. We have encouraging or educational provisions for the trustee about advocates and the hiring of advocates. There would be a memorandum or a binder or both attached to the trust. There would be flexibility for trust advisory committees or other flexibility. And there would be special considerations for retirement plans. So many of you, your larger assets are retirement type plans that are going to come to the special needs trust for your loved one. And it's a good thing to remember that Uncle Sam is giving us a break when it comes to special needs or chronic illness, but others who are healthy and well and neurotypical children are not given that exemption and are going to have to pay all the tax on their IRAs in about 10 years or less. But here we know that people with disabilities, most of them that are under SSI or SSDI and are basically meeting the requirements of the rules, they are going to not be subject to the 10-year rule. We want to make sure that the Special Needs Trust recognizes them as eligible designated beneficiaries. Eligible designated beneficiaries, so that they get special tax treatment, favorable tax treatment for IRA purposes. And this leads us to talking about the Secure Act. So a person who receives an inherited IRA after 2020 is going to have to pay tax in 10 years unless they meet one of these exemptions. So from an estate planning point of view and a special needs planning point of view, we want to review your current documents, review your current assets with you and your financial advisor and CPA, and also make sure that we understand how those assets are flowing and making sure that if you're leaving an IRA to a person with disabilities, that that person definitely will be exempt from the 10-year rule. Now, here are some trustees. Jeff's been looking a long time and he found these two individuals and he said, Steve, these people are wonderful trustees. They do all of these things. They advocate, they understand public benefits, they promote the quality of life of an individual, they are in touch, they understand what's going on in that person's life, they are accountable, they keep accurate records, they keep the beneficiary informed. And by the way, a loved one with disabilities that is maybe higher functioning and asks questions and wants information, they are entitled to that information. And the trustee complies with their statutory duties, and there are statutory duties under the Maryland Trust Act of 2014. And while they are not investing the money themselves, unless they're a professional investor, they are hiring professionals to do the investing, to do the taxes, to get advice. These are the trustees that are doing these high-level things that are expected. So as you think about trustee selection, these are kind of a starting point in those concentric circles. Now, many of you are going to be concerned about what can a supplemental needs trust pay for? Well, they can pay for anything that's for the benefit of the beneficiary, basically, within reason. And we are happy to provide a list for you. But as a basic idea, anything that's really going to enhance the quality of that person's life that doesn't have anything to do with substance abuse, doesn't have anything to do with gambling or other activities like that, is an appropriate expenditure from a supplemental needs trust. Now, we talked about this early on. How much should you fund into a special needs trust or supplemental needs trust? Remember, you're going to decide this based on your own financial situation. Some of you are not going to be concerned about this. Others of you are going to say, well, Steve, I'm not quite sure about this. So as a fundamental premise, I would just recommend again, look at life insurance as a funding tool. Look at your special needs plan in relation to retirement assets. Use the services of a good financial planner. And for those of you who do not have a life insurance specialist, we certainly would recommend Max Reamer, who spoke at our client event a couple of years ago. He's a super knowledgeable person about life insurance, and of course there are other professionals that are available. The first party trust, as I mentioned, is a trust where the person has received money in their own name that they cannot have and should not have received, but maybe they had no choice. It was a litigation settlement, or a well-meaning relative left money to them. And that's what this slide is covering. It was a personal injury award or an inheritance, and now we've got to get that money out of that person's name. So just know that this is a blessing that we actually have this ability to do this, but it does have a payback. So we don't want to use a first party trust unless we absolutely have to. But if you do have a loved one, whoever does receive money, remember, you're worried about a lot of things. I know you are, but this is not something you need to worry about here, because this can be taken care of if it ever happens. Now, as we get toward the real latter part of our presentation, what is the process? Well, I apologize in advance for this very strange looking wave of process that we have here. Basically, what this is saying in so many words is that we want to have an advisory team, and this could include a life insurance specialist, it could include an advocate, but surrounding that team, we want to do some meetings. We want to review documents. We want to take the time to appoint trustees. We want to understand what happens at our death. One of the big questions that comes up is, what happens when it's time to file the tax return every year for the trust, and how does that affect my loved one? So there's a lot of education, and also our firm is known for having family meetings. So if at the end of a process of planning, you wanted to convene, I should say, a meeting of your financial advisors or family members, we want to have that meeting to make sure that everybody is updated and educated, and including yourself, of course. This is a little better way of looking at this. I don't know if you can see this or not, but the thing to take away from this is that you don't want to do planning as a transaction. You want to do planning as a process, and it doesn't matter whether there's 6 steps or 4 steps or 7 steps. What matters is that you're getting educated, you're making informed decisions, you're building in flexibility in most cases, and you have a good understanding, and so do your fiduciaries, and the planning is going to be properly funded. That's really what matters. Now, we talked about this a little bit, whether or not we should get guardianship of our loved one, go through that process. For some of you, this is going to be very straightforward. Your loved one is vulnerable, your loved one is disabled, you're going to get guardianship of their person or person and property, and it is going to be something that is going to be necessary. And it's going to be an uncontested guardianship. There's not going to be any fireworks. It's going to be very straightforward. For some of you, guardianship would be more of a challenge. Your loved one would resist, or your loved one would not acquiesce to a guardianship. So this is a counseling issue, and we understand that this is not an easy decision. As I mentioned, there's guardianship of the person, guardianship of the property. Now, supported decision making, we have an entire webinar on that, but I was very fortunate years ago to meet one of the key players in supported decision making in Maryland that basically led to the passage of the supported decision making bill in Maryland. And Megan Rusiano and other champions of this law were effective, even though they had to battle uphill for many years. Some of you are going to understand what supported decision making is, and you already do. You know it's a tool to give power or support or accommodations to people who are disabled. Maryland does not provide a form yet. We have to create our own form, and we've done that here at Elville Associates if you would like to get your loved one signing, if they are capable of doing it, a supported decision-making agreement. Now, the law is so broad that it does not even require them to sign a signed agreement. And that's going to be sensible to some of you and not sensible to others of you. Some of you are going to embrace supported decision-making. Some of you are going to, I'm trying to go backwards now, sorry. Some of you will not embrace it. Some of you will be mystified by it. What does it do? What is this going to mean? How is this a good thing for my loved one? So you're going to look at this in different ways, is my experience with this. But I want to just let you know that it is a part of this continuum of capacity versus incapacity and a new way of looking at the world for your loved one with disabilities. And again, if I could define what supported decision-making is for you, I would say this, for those of you who do not know this. Look at this top bullet point, and I would say this is really what how I would look at it if I were you. It is a tool where a person with disabilities, no matter how much they are disabled or how little they are disabled, they are in theory empowered and supported to make their own decisions to whatever extent is possible. So let me rephrase that. Let's say, was a person with disabilities. I have the right to make my own decisions to whatever extent possible, provided that I have the support to do so. It's a simple concept. It does take a little bit of thinking for some people to get their minds around that simple concept. I, as a disabled person, have the power to be supported to make my own decisions to whatever extent that I can make those decisions. I'm going to do that. So there's no loss of rights. There's no guardianship. Last thing I'll say about this as we start to wrap up, Maryland is so broad in its approach to this that even under guardianship, a person is allowed to have a supporter. However, my exposure to it so far over the last 2.5 years is that courts are reluctant to allow a person under guardianship to have a supporter, even though the law says that. So I think Maryland law is still evolving around this. So as we think through this, we want to create a memorandum of intent or a binder. Start your own estate plan. If you already have one, you're going to want to review it. We want to establish a special needs type of plan, a special needs trust. And if you have one already, we want to review it, see if we can modify it or if we need to. We want to go through the process. The process is driven by goals and purpose. If you don't know your goals, we're going to help you think through that. We want to use tools to think about the future, Monte Carlo simulations or funding with life insurance. We want to name the special needs trust as a beneficiary of our retirement plan assets and make sure that our loved ones with disabilities don't have to pay tax on IRAs within 10 years like other people will have to do. We want to understand public benefits, make plans for the future, make sure trustees are educated, think about advocates. And we know you're already overwhelmed, but we want to make sure that we've adequately designed and structured special needs planning the way it's supposed to be as part of your own estate plan. So as we wrap up, and we're right here at 11 o'clock in 1 minute, we want to give you a path forward. So we want to educate you, but also not get into a stagnant process here, just educating ourselves. We want to give you a path forward. Remember, if you come in and meet with me or one of our really fine associates here at Elville Associates, they're very committed to special needs planning and planning for people with disabilities. It doesn't cost anything to have a consultation. We do review most documents that you may already have with no charge. We want to help you. If you could please complete an estate planning questionnaire, that would be a good step so we can learn more about you. There's nothing to fear, remember, because even though you're sharing information with people you've never met per se, that is protected by the attorney-client privilege, even if you decide not to become a client. So we want to see those existing documents. We want to know who your financial advisors are in your team. If you don't have one, we want to help you establish one. We love it when you have questions, so thank you to those of you this morning who did ask questions. It makes the seminar better. bring those questions in. Let us tackle those questions that you may have. And we want to give you the time to think, because we know you don't have much time and you're being bombarded by the 24-hour news cycle. We want to take some quiet time together with our high-tech equipment here to really get into the nitty-gritty of how to get peace of mind and get the planning in place. Jeff, I'm going to turn it back to you. I hope you feel better after today, and I hope everybody makes it through the weekend and the snowstorms that are coming up, and that you have a wonderful weekend ahead.
Steve, thank you. Just great information as always on such an important topic that's important to everyone here, including us at Elville Associates. Steve, you ready for a speed round of questions?
I am.
Okay. Each one is worth $50 for a correct answer. Okay, can you talk just a bit about the pooled trust and any advantages and disadvantages to that? I know you alluded to that briefly.
Thank you very much. A pooled first party trust is something like the Maryland First Disability Trust, which is a very well-known pooled trust in Maryland, or First Horizons, which is in DC, or the ARC of Northern Virginia. These are nonprofits that run a pooled trust. So it is what I would describe as a inexpensive way to establish a special needs trust when a person has already received money that they shouldn't have. A good example would be someone who's got $50,000 in their name and they shouldn't have that. It's knocking them off of benefits. Well, it's easy to, quote, dump that money into a pooled trust. Now, I personally think that pooled trusts are not always the solution, and maybe the other first party trust, the D4A trust, is the solution, because the trustee or the family can have more control over that money, whereas the pooled trust is going to have its own trustee. And I'm not saying this is a bad thing. The cost is probably less to get that established, but you are not going to be in control of the distributions. The other party, the trustee of the pooled trust, would be in charge. And then remember, at the death of your loved one, whatever is in that pooled trust is going to go to the pool. Now, these pooled trusts serve a good purpose. They're important, but the D4A trust might be the thing that has got more control, or for larger settlements. Again, opinions are going to vary on this. The person who is under 65 can use the D4A trust, but let's say we had a person who was 75 and they had too much money in their name. We would have no choice but to dump the money into the pooled trust, for example. But that's what a pooled trust is, and they have their purpose, and some of them are very, very important.
Okay. Next is, can a Title 13 trust be changed to a special needs trust if it is still a minor?
Excellent question. In my opinion, yes, because when we think about this, the Title 13 trust, as far as to my knowledge, is going to become the property of the child when they're 18. So we want to, I think, get away from the Title 13 trust situation if we can by the time that child's 18 anyway. So in my opinion, subject to the facts and circumstances there with that particular case, is yes.
Okay. Is there a sample rental agreement for adult children applying for or receiving SSI?
Yes, we've been using kind of a simple form for all these years, and that seems to work just fine. So we're happy to send that to you. It's a simple rental agreement. And Jeff, if you'll make a note or email us, we will be glad to send.
Okay. If a grandparent establishes a third-party trust for a disabled grandchild, can other family members or friends contribute to that trust, or do separate trusts need to be established?
Wonderful question. Thank you for that. The answer is absolutely yes. So if that wonderful grandparent establishes a third-party trust and other people want to contribute to it, that's exactly one of the major reasons to create a separate trust like this standalone trust, I should say, is to be able to let other people contribute to it, and they do not have to create, as long as they agree with the terms and provisions of what grandmother is making as far as this trust goes, they do not have to create their own trust.
Okay. I have two disabled children. Do they each need their own trust, or can it be grouped for them both?
Thank you for that wonderful question. I think there are nuances in Maryland law that would suggest they should each have a separate trust. In various states, it would be routine to have one trust for both of those children, but it's been my practice and my understanding from other colleagues that this would be the approach we would take in Maryland, is two separate trusts.
Okay. I'm going to group two questions together here. Does a trustee have to be chosen at the time of opening a third-party special needs trust, and another person having trouble making a plan for trustees? And you mentioned help with that, and how would that work?
Yes, thank you. So the answer is yes. You would have to know who the trustee is, because the whole premise of creating a trust is kind of creating a contract. So the contract kind of says this is how the trust will be administered, and it is being accepted by a trustee who agrees that they will administer it. So you do have to have a trustee, and we can think about that, which gets to your second question, which is a great one, of how would we do that? Well, we would probably sit like right here in the conference room where I'm at right now, and we would just think through your issues, think through your family situation, process of elimination, start thinking about the people in your life, the relationships you have, like financial advisors, or maybe you don't, or maybe you do have relationships with a certain bank, and the size of your assets. Do you have the kind of assets where you could use a corporate trustee? Or maybe it should be an independent person, or maybe you have siblings. So we just kind of think through all these relationships and how that relates to your child's age, your financial assets, your age, all of those things, is kind of working through a process to see how can we structure trustees. And it could take 2 or 3 meetings or more, not just talking about trustees, but talking about the planning overall. That's really what I'm encouraging you to do, is taking the time to think. And then I predict that when you kind of understand what all the choices are, you'll have many more tools to be able to make these decisions, and you will be able to make decisions.
Okay. A few more here. Does a special needs trust reduce SSI, or does it have tax implications?
Jeff, did you say, does a special needs trust reduce SSI?
Yes.
Oh, good question. The answer is no. So your special or supplemental needs trust stands on its own, and if it's properly drafted, it is not an available resource to the person for public benefit purposes or means tested benefits like SSI. So it would not reduce SSI. The only way, in other words, the trust in and of itself would not reduce SSI. But let's pretend that your loved one was on SSI and the trust paid for an apartment for that person. So the trust pays for their housing, pays for the apartment. The Social Security, or SSI, is going to reduce your child's SSI by 1/3. So a distribution for housing or support, housing, for example, would reduce the SSI, but the trust itself does not reduce anything. It's exempt for SSI purposes.
Okay. And a couple more here. Can a parent with end-stage dementia be deemed disabled and incapacitated and have a special needs trust established third party for them?
Yes, thank you for that wonderful question. Yes, so someone who wants to leave money, and I don't know the situation you're describing, but let's pretend that you want to leave money or give money upstream to a parent. That person could have that money in a supplemental needs trust, and that will exempt it from long-term care Medicaid as well.
Okay, are there any tax implications for the parent if the child with special needs has a rental agreement?
Well, let's think through that for a second. So I'd have to know more about the facts and circumstances, to be honest with you. There certainly are tax implications for the parents. I would just have to kind of know, is the property in the trust, is the property outside of a trust, and the parent is receiving rental payments. So I'd have to know more about that. So please, feel free after today to send me a more detailed message about that.
Okay. Does anything change if the beneficiary of a third-party trust moves to a different state?
Thank you for that. So today's trusts, not all of them, but for example, the ones that we do are contemporary in the sense that we understand that people could move. We've had several examples of people moving to other states or children with disabilities moving to Washington State, let's say. All kinds of situations occur. So as long as the trust provides for flexibility, the trust is located in Maryland, let's say, and it's governed by Maryland law. And it's created, let's say, under the Maryland Discretionary Trust Act. So it's a valid special needs trust. But now that child moves to another state, moves to Washington, moves to another state. Well, that state probably has its own Special Needs Discretionary Trust Act kind of law. So what we want to do is have a trust protector to be able to make the provisions, change the provisions so that the trust can move to the new state as to its location, which is its situs, and to its state law. So absolutely, trust can be moved to the other state where the child moves. And there are ways of taking an old trust that doesn't have those kind of provisions and updating the trust so it's more flexible. So don't worry about that too much.
Okay. And one more, and before that, a comment regarding the rental agreement, tax implications. Our client here says the condo she's alluding to is in the trust, if that is at all helpful.
Okay, well, if there's a condo in a trust and then there's a rental agreement, I guess the question is going to be to look at that trust and say, okay, can we really require that child to pay rent? How much money is in that trust? There are just all kinds of circumstances. So I would appreciate it if you could elaborate more on that and what your concern is about the tax implications that you may be concerned about.
Okay. And last one, regarding estate or inheritance tax, does Maryland law apply to special needs trusts? Says she's trying to decide what state residence should be determined.
Gotcha. So if you were to provide a disposition to someone who was subject to Maryland inheritance tax. So Maryland, it has abolished inheritance tax as to most people except they have abolished it as to lineal descendants, but except to nieces and nephews and people that are more remote is an easy way of establishing it, of thinking about it. So if you leave assets to someone with special needs who is subject to inheritance tax, which is one form of death tax, that person is still going to be subject to that inheritance tax. Now, the Maryland estate tax and the federal estate tax apply to every person. And when someone dies, that estate tax for that person at their generational level, that has to be dealt with as part of or prior to the distribution to a special needs trust. Now, as far as assets going into the special needs trust, depending on how the special needs trust is drafted, Uncle Sam could come down to the level of that person who has the special needs trust and at their death impose inheritance or estate tax at that level, as I should say, death tax like estate tax at that level as well. Now you can structure that in such a way that it would not be taxable for estate tax purposes at that generational level as well. But yes, Uncle Sam will try to estate tax and inheritance tax you based on who you're leaving it to at your death. But when you leave assets down to the special needs trust, we can look at that issue and say, do we have estate tax concerns at the death of the disabled person where those assets could actually be taxed again for estate tax purposes? So that's a good question if I understood it correctly.
Okay. Steve, thanks for a great presentation.
Thank you, Jeff. And I hope you feel better, and I hope everybody got something out of this. And thank you for the wonderful questions.
Yeah, great questions today. And as always, I'm going to send out a message with a lot of information that Steve alluded to, lots of different links, Kevin Urbash's book, the rental agreement, what trust can pay for. We have lots of presentations coming up as part of our webinar series, including some in-person ones over the next 6 weeks or so. So I'll be able to send that information out to you as well, and hope to see you again soon on the Elville webinar series, and hope you have a great weekend too. Take care, everybody.
Thank you.